So I think we can probably get started. It's a little bit after 8 o'clock. My name is Andrew. I'm here with my colleague Denise, really to just at a high level run through what employees are entitled to when they've lost their job. We're aware of a lot of the downsizing going on, particularly in the tech industry right now. IBM, Shopify, Mitel, and a lot of, particularly in Ottawa, but across Ontario and Canada more broadly, large tech employers have been terminating significant numbers of employees. And, in our view, it's helpful that people understand what they're entitled to so that you can sort of help decide whether or not you need any kind of legal advice in your particular situation. So we're going to run through what rights you're entitled to when you've lost your job. We're going to run through how you calculate the value of any severance packages you might be entitled to. We're going to run through some other issues, including human rights or bad faith behavior. And then at a really, really high level, just talk about how do you negotiate a package, or what are strategies that some people use for negotiating an improvement to their severance package when they've been let go. So I'm going to start with the first sort of question that we have, which is really, what is a without cause termination? And really, that's what's going on in the tech industry right now. When there's mass layoffs, it is almost always a without cause termination, which really just means the employer is firing somebody without a reason, which is allowed in Ontario. The rule is you can basically let anybody go for any reason under the sun, as long as you pay them. And what we're going to sort of dive into is how you calculate what that payment is. This is sort of the opposite of a with cause termination, which is the employer had a good reason to fire you. It has to usually be a very serious reason. Employment lawyers often describe it as the capital punishment of employment law, because a with cause termination allows them to fire you without any compensation. There are still some sort of middle ground categories where you're still entitled to some compensation, even though it might be for cause. We're not going to get into that. But basically, the difference between a without cause and a with cause termination is, did you do something wrong that justified the termination? Another thing that just relates to that I'm just going to quickly close off on is I often get people asking, oh, well, was I constructively dismissed as well? And it's a common question, but it's actually the wrong question to ask, because a constructive dismissal is where an employer has not fired you, but they've just behaved in a way that lets you resign and seek the same compensation you would get if they fired you. So for example, if it was a toxic workplace, or if you were earning $150,000 a year and the employer comes to you and says, we're going to start paying you $100,000 a year. You might be able to say, I've been constructively terminated, but all you get is the same type of compensation you would get if they just fired you outright. So if you're coming to the session because you want to understand what you're entitled to when you've just been let go, you really don't need to worry about a constructive dismissal, because you've already established that you've been fired or terminated, and so it's not relevant. So once you've been fired, you start to look at three different things for the type of compensation you're entitled to. First is the Employment Standards Act. Second is your employment contract. And third is reasonable notice. I'm going to hand it over to my colleague, Denise, who's going to start with the Employment Standard Act minimums.
Thanks, Andrew. The Employment Standards Act, that's the piece of legislation that governs what you're entitled to if you lose your job without cause. Again, a couple of different middle ground exceptions there, but we're just going to assume, it's a without cause termination. So step one is you look at the Employment Standards Act, or ESA, and that's the very bare minimum that your employer has to pay you out. So you can't say, I'm going to pay you less than what you're entitled to under the ESA. The way that you want to calculate your termination entitlements under the ESA is you're going to look at two different branches of entitlements. So the first one is statutory notice, and the second one is statutory severance. For statutory notice, the employee who's been terminated, you get 1 week, 1 week per year of service up until a max of 8 weeks. That can be paid out, or your employer can ask you to work for that statutory notice. So for example, if I've been there for 8 years and I'm just terminated, I get 8 weeks of statutory notice. My employer can ask me to work for 4 of those weeks, and they can pay out the other 4. So that's the first branch, is statutory notice. The second one is statutory severance under the ESA. Now, this one doesn't come automatically. You have to have been with your employer for at least 5 years. So you have to have 5 years of service, and your employer has to have a payroll of at least 2.5 million to qualify for statutory severance. So if you check off those boxes, then you're entitled to 1 week per year of service up until a max of 26 weeks. Now, remember, with statutory notice, you could get pay in lieu, or you could be, told to work out your statutory notice. Well, severance is different. The employer has to pay that out. So those are your two basic minimum entitlements under the Employment Standards Act that your employer absolutely has to comply with on a without cause termination. And if you're scratching your head and thinking, wait a minute, what I've been offered seems to be less than what my ESA minimums are, then that's definitely a reason to take a deeper dive into your termination package and perhaps get some advice. So those are the minimum entitlements for regular terminations. I'm going to touch very briefly on group terminations because the minimum entitlements are calculated a little bit differently. So group termination entitlements apply if you have a group of at least 50 employees who have been let go within a period of 4 weeks. So remember that first prong, the statutory notice that was 1 week per year of service until the max of 8. Well, that's calculated differently if you're in a situation where there's a group termination. So there's actually quite a handy guide online that just the ESA guide to Employment Standards Act, and it explains how this is calculated. So you've got, 3 different branches, 3 different categories of entitlements for statutory notice and group terminations. So you get 8 weeks if it's 50 to 199 employees who have been terminated. And then if it's 200 to 499 employees terminated, then you get 12 weeks. And then if it's 500 or more employees terminated, then you get 16 weeks. So obviously more generous than the usual statutory notice that applies in individual circumstances.
I might just jump in because there was a question that related to this, Denise, in the chat. So how do I know if I'm technically part of a mass termination? Well, so there are actually really specific rules that employers have to abide by if they conducted a mass termination. So there's a specific form and a notice that they have to give, I believe, to the ministry that they would have to submit. So that would be your first, I think, point of reference would be to, try and find that notice. Yeah, that's kind of where I would start in contacting, the ministry page. Yeah, and sometimes employers do, and sometimes they don't actually submit that form, so it can sometimes be difficult to figure that out. Sort of jumping off that, one of the other things a lot of people often do is actually just talking to their colleagues and sometimes kind of whispering in the ears of the managers and whatnot who are still there to get a sense of, how many people were let go and, when was it all happening? I mean, often for these mass ones like we see right now, it gets covered in by CBC and major news outlets, so you can sometimes figure it out there. But in our experience, sometimes employers can be a little bit cagey about it and also can take some positions that, it only applies if you're at the same, physical workplace and doesn't apply if it's, Toronto, Ottawa, and Waterloo that all have offices and whatnot. And some of that law is still in a little bit of flux. But it can be difficult to get that information. And sometimes you have to actually sue before the employer will even voluntarily give it up. The problem for the employer is they can sort of be subject to claims of bad faith behavior if they are sort of misleading or disguising a mass termination. So it's generally not a good tactic by employers to disguise mass terminations, but it's not like it never happens. But yeah. So Denise, did you have anything else about employment standards before we move to the next sort of bucket?
No, I think that's a pretty good segue into, that next step. So you've got your minimum entitlements, and then what's the next step that I look at if I'm trying to figure out what I'm owed? And that's looking at your contract. So I'll hand it over to you.
Yeah, so I mean, the starting point for any employment lawyer when they're meeting with a new client is to say, can you show me your employment contract? And that is because this is the most determinative thing about what you're going to get if you're ever let go. And every employment contract is different. Every employer has its own termination clause. And even within the same employer, often many employees will have many different clauses. And so that's why it's often important to get your individual clause looked at. Not to mention the circumstances of you signing your employment contract could, for one employee, it's enforceable and another it's not. For example, if they tried to change the termination clause on you while you were already working there, there are some issues in terms of the employer enforcing it. So first thing is you always have to look at your employment contract. There's generally a few different types of employment or termination clauses that we see in employment contracts. The main one is often one that actually just tries to restrict the employee just to their Employment Standards Act minimums. So courts have said that in a person's employment contract, you can say, I will only pay you your Employment Standards Act minimums and nothing further. And for the most part, courts have said that's fine. And if that's the case, and if they sort of check certain boxes they have to check, a court will say you only get your Employment Standard Act minimum. So let's say you're an employee for 26 years with an organization, you only get the 8 weeks of termination pay, and you only get a maximum of 26 weeks or a week per year service of statutory severance. And so that can be really disappointing to someone who's had long service and learns that their employment contract has some Employment Standards Act clause. But often those clauses are illegal, and I don't think it's worth getting into the various circumstances of how and why they're illegal. But one of the things that employment lawyers are always doing is looking at these types of contracts to see, are they illegal? Because if they're illegal, you can get more, which is your common law notice, which I'm going to talk to in a second. So first type of contract we see is the ESA amounts. Some are legal, some are not. You probably need somebody to look at it to figure that out. The second one is one that will contain a formula that says how much you get. So sometimes what the contract will say is, in addition to your Employment Standards Act amounts, we're going to pay you another 2 weeks of salary per year of service, or 4 weeks per year of service, or 6 or 8. And it creates some mathematical formula that you're entitled to. And so as long as that formula does not fall offside of the Employment Standards Act amounts, for example, by offering you less, that's usually what you would get, is what's set out on that employment contract. Although, again, the circumstances can really vary as to whether it's enforceable or not. The final type of employment contract we sometimes see is one that is silent on what you're entitled to on termination, because either A, you just never had an employment contract, which is common, or B, you have an employment contract that's really just, said some stuff, but nothing about what you're going to get when you've been terminated. It's really just a confirmation of employment or something like that. In those cases, courts have unequivocally said you are entitled to common law notice, which is that type of notice I was mentioning that is much more generous. And so really, maybe I'll go there, but just to really summarize, you usually either have an Employment Standards Act amount, some formula that calculates what you're entitled to, or nothing, which then gets you to common law reasonable notice. With respect to common law reasonable notice, the way you calculate that is very individual. Courts will say that there's no magic formula, or there's no sort of way that we calculate this consistently for everyone, but most employment lawyers will tell you the formula is actually really a month per year of service. And courts kind of pay lip service to the fact that there's no formula, and then apply a formula of roughly a month per year of service. That said, that month per year of service gets adjusted up or down based on factors such as your age, how senior in the organization you are, and senior in terms of sometimes management or senior management roles get longer notice. Is there a disability or some kind of medical issue that might impact your ability to find new work? Are you pregnant? Often courts will add to the notice period for somebody who's pregnant or has just had a child. Is it a bad job market right now? Is the tech industry in the middle of mass layoffs, which is going to make it really difficult for people to find new jobs? Those are all things that courts look at to determine, how much above or below that month worth per year of service worth of notice that you get. But again, that's going to really depend on your situation. I think that's all I really had to say about that, because I'm going to flip it over to Denise, who's going to talk about the duty to mitigate. But, you know, at a high level, if you've been somewhere for 12 years, you're in your 60s, it's pretty easy for an employment lawyer to say, look, you're probably going to get at least 12 months per year of service, or sorry, 12 months total, maybe more because of your age, but you know, that's easy. If you're 32 and you're a coder and there's a bunch of jobs and you've only worked there for 2 years, that's trickier. Could be 3 months, could be 6. It's going to depend on the judge. But again, that's what I mean by it's a very individual assessment. And a lot of it's going to depend on sort of what your circumstances are at the time. But I'm going to flip it over to Denise now to talk about the duty to mitigate, which really matters for the person I just told you about who might get 12 months. So Denise, over to you.
Yeah, so just to bounce off the example Andrew was giving. So say that you're entitled to a 12-month reasonable notice period. Well, during that time, you have what's called the duty to mitigate. And that means that you have to make efforts to try to find comparable employment. So what can actually happen to employees who don't discharge their duty to mitigate is that they can actually have a credit or a discount, applied to their reasonable notice award. So they can have their damages deducted, meaning that the amount in your pocket is lesser if you don't discharge your duty to mitigate. Now, what exactly, does that mean? Like going out and finding new work? That means finding comparable employment. So it's a job that's comparable to the one that you just lost. It doesn't mean accepting something that's, pays a third of what your former employment paid, or it's drastically different. It really is a case-by-case basis. But if you go see any employment lawyer, one of the first things they will tell you, and I know we're saying that there are a lot of first things to consider, but one of the other things they will tell you is, go and make sure that you're documenting all of your efforts to find new work. So that includes anything from your cold calls to LinkedIn messages to emails to people, because you want to show the employer at the end of the line, if mitigation does become an issue, that you did everything that you could have reasonably done to find new work and that you just couldn't for whatever reason. Now, flip side of the coin is, say you're at month 6 of your 12-month notice period and you find a job that is very similar to the one you've lost and it pays the same. Well, then the employer does get a credit for the balance of your reasonable notice period. So they get a credit for the rest of those 6 months, because it's essentially, against the principle of double recovery if you got the 12 months plus all the money that you're going to make from your new employment. So bottom line is, you do get a bit of a acclimatization period after you lose your job. Of course, don't expect that you're gonna, jump up the next day and start going to interviews right after you've lost your employment. So you get a little bit of time to find your footing, but after a reasonable amount of time, you want to start making some efforts to show that you're actually, looking for new work and trying to minimize your losses. So I'm still going to use that 12-month notice period example. We're saying you get 12 months. Well, what does that exactly mean? That means that your employer, your former employer now at this point, has to continue all terms and conditions of your pay during those 12 months. So that includes things like your base salary, your benefits, if you had even a cell phone allowance, things like that are normally part of your compensation package, your employer has to continue. It gets a little bit trickier when we have more, sophisticated compensation that include things like stock options or bonuses or commissions, and there are specific rules that apply to each of those types of remuneration. So it's, again, actually really important to get legal advice if you have a complex compensation structure, because those will be applied. The rules around that are a little tricky, but generally speaking, absent anything absent a clear restriction and a clear right to the continuation of all of your, bonuses, for example, your employer still has to continue your remuneration as if you were still working during that 12-month notice period.
Yeah, and I'll maybe pick up on just a couple of points related to that too. First, with the duty to mitigate stuff, I think Denise already said this, but it doesn't apply to your Employment Standards Act amounts. So even if you find a new job the next day that you've been fired and you already have another job in your pocket and you go take it, you get your Employment Standards Act amounts no matter what and no matter what your contract says. The second exception to the duty to mitigate is if you have either a fixed term contract, which means, you have a contract that says you're going to stay employed for 3 years or something like that. Courts have generally said that that you get the value of that whole contract, or your losses during the notice period are that whole contract. And even if you find new work, the employer doesn't get to claim an offset. The sort of third exception to that, where you get to kind of keep your full losses, is that sort of second category of contracts I talked about, but where your contract has a formula that says, you get 3 weeks per year of service. Courts have said that the duty to mitigate does not apply, meaning you get the full value of that formula, even if you find a job the next day. Again, employers can always sort of work around that in the contract, so they can always build into the contract that you get 3 weeks per year of service, but it's reduced by mitigation earnings, which again, that's just lawyer speak for like new earnings. So you have to be very careful about that. It's not always that way, but usually if you have any of those things in your contract, that's the case. The other thing, just to pick up off of Denise's point about sort of other compensation systems like bonuses, RSUs, stock options, things like that, is you often have to look around the employment contract and go to the contracts that govern those specific types of compensation to figure out what you're entitled to. Because you may have an employment contract that says you're entitled to one thing when you've been let go. For example, maybe it says you're entitled to a year's worth of notice, including, all your salary benefits and stuff like that. But then you go look at the stock option grant or the RSU grant, and the RSU grant says something along the lines of it ceases as soon as you've been terminated, or it ceases at the end of the Employment Standards Act, notice period. That may actually create a situation where either A, your employment contract and termination clauses are unenforceable because it's sort of uncertain as to what you're entitled to because you have these two different contracts saying different things, or you're entitled to one thing for your salary and benefits and stuff like that, and a different thing for your RSUs. And so that's really where when Denise was saying kind of you got to be careful about things, that's partly why is sometimes even, they will contradict each other or say completely different things from what your employment contract is saying. And those need to be looked at really, really closely. The other thing to just sort of pick up off of in terms of what you're entitled to during a notice period. So a notice period, again, that's just when we say somebody's entitled to 12 months severance or common law notice or whatever. We're just saying that's notice period. Is for salespeople in particular, but people who are heavily bonused, where there are big swings in their compensation. So for example, you get a performance bonus one year, it's $5,000, the next year it's $50,000, and the next year it's 20, and then the next year it's 70, and it kind of flips back and forth. Or, you often see this in sales where maybe somebody is a salesperson who has a 3-year sales cycle and they have massive sales commissions every 3 years, and then very small compensation for 2, and then massive sales commissions for 1 year, and then very small for 2, and it kind of repeats on that pattern. Courts are able to look at that and try and figure out a fair and equitable way to actually compensate people in those situations. But again, how they do it varies. It depends on what the comp plan says. It depends on what the person's history was. A lot of things that have to be looked at individually, but there are always ways of sort of working around those sort of, distinct issues that everybody has. So there's a couple questions, but maybe I'll sort of park them to the end because I think it's probably better to deal with it that way. So Denise, I'm going to pass it back over to you to talk about some of the issues that arise outside of, reasonable notice or outside of sort of your contractual entitlements when you've been let go.
Yeah, so I'm going to shift a little bit now to talk about two principles. The first is bad faith, and the second is our human rights issues. So with respect to bad faith, your employer has a common law duty of good faith towards employees. And if they breach that duty, then they can be on the hook to pay for that breach. So employers have a duty during the course of your employment, during the course of dismissal, and actually, their behavior post dismissal can be counted, taken into account when we're looking at whether the employer has discharged their duty of good faith. So what's an example of bad faith? Well, during the employment, treating somebody, subjecting somebody to a toxic work environment, that can be an example. If the reasons for the termination are disguised, if they're giving you a totally different reason, example, you filed a harassment complaint and then the next day you get terminated, that can be a hint towards making out a bad faith claim. But what about, after you're terminated? What can possibly constitute bad faith post termination? Examples of that could be, failing to pay out your statutory minimums, like those amounts we were talking about at the beginning of the session. Employers have a strict timeline of when they're supposed to pay those out. And if they don't pay them out in a timely way, that can open the door to a bad faith claim. Not issuing your record of employment. If in the manner of your actual dismissal, so if during the meeting itself, you were treated in a really insensitive way and marched out the door with your box of belongings and all of your coworkers witnessed it and it was extremely embarrassing, that could be a factor militating towards a bad faith claim. So things like that, and typically people are really good at identifying things that just, were beyond the normal discomfort of a termination or the normal discomfort of, workplace conflict and stuff like that. So it's important to voice those concerns if you're having, that nagging feeling that something just wasn't right, and to talk to someone about it, because there might be more to it than you think. Kind of along that same line, with respect to, your right to protection against discrimination. So the Ontario Human Rights Code explicitly states that you have a right to employment free from discrimination, and discrimination is when you treat someone differently based on what's called a prohibited ground. So that can be something like disability. So for example, you advised your employer that you have mental illness that needs to be accommodated, and then the next, just use an extreme example, next day you get terminated. Well, that raises some questions, and that could open the door to human rights damages, because if the termination itself or if your treatment is tainted by discriminatory conduct, then you could have the right to damages under the Human Rights Code. So, and again, people are typically really good at identifying things that just don't sit, something's just not right. But it's taking that next step and actually talking to someone about it and talking to the lawyer about it to figure out, is there actually a claim here? Was this beyond just the normal discomfort of, again, like workplace conflict or the discomfort of losing your job? And it's better to turn over that stone and think about and talk it through with a lawyer than to, sign a release, which Andrew's going to talk about, and then, be regretting that decision later on.
Yeah, and just sort of to piggyback off that a little bit, like a lot of the situations we often see are murky. It's, 5 people were let go. I was one of them, and I told them 2 weeks ago that I was pregnant and taking leave. And it can be sort of hard to sort of work through, well, is it, was I just one of 5 people who were randomly selected, or was I one of these 5 because they knew my pregnancy leave was coming? And courts and human rights tribunals tend to take a fairly flexible approach in looking at these types of situations. They tend to recognize sort of the injustice and the idea that even one of the 4 was pregnant, and it kind of looks a little bit suspicious as to why that person was selected as opposed to somebody who, was comparable performer or had been with the employer a similar amount of time, and are able actually to look back and say, look, on its face, this looks discriminatory. And so employer, you actually have to justify your decision. You have to show us why there was a legitimate business reason for what you did. And so, yeah, we see it a lot with disability. We certainly see it a lot with pregnancy. Often sort of that situation Denise said, harassment. So somebody makes a human rights-based harassment complaint. So I was being discriminated against based on my race or treated differently based on my race. And then sort of gets let go a few weeks or months later under some sort of reorganizing or something that on its face seems neutral. There is still a way to look past the curtain and kind of say, hang on a sec, is this person really being just let go because they complained or because they had this protected ground? So it's, again, one of the reasons why you need to sort of figure out your specific situation. And, moving to my next point, which is about releases, why it's really important you do that before you sign a release. Because often somebody's let go, and if you're on this Zoom, you probably are in the situation where a pile of money has been offered to you. And so I understand the instinct that somebody has to immediately just sign the documents to try and get maybe a, $20, $30, $100,000 lump sum of money, which depending on what you were paid and how long you've been with the employer, it could be, in the hundreds of thousands. But the second you sign it, there is almost nothing that a lawyer's going to be able to do for you. It's one of those situations that unfortunately happens a lot, that people come and ask for advice and have already signed something, and we have to say, I'm really, really sorry. There's nothing I can do for you. You may have the best case in the world, and there is absolutely nothing I can do for you because you signed that release.
Mhm.
And so,
just jumping off of that too, and I think another reason that people feel pressure to go to sign the package is because there are often deadlines that are included in your termination letter, where they'll say, here's what we're willing to offer you, and you have a week to accept this, and that can be really daunting to read. So then you might have the instinct of just signing the release, but those deadlines are typically artificial. And you can almost always ask for an extension to them, and actually take the time that you need to consider what's being put in front of you and speak with a lawyer.
yeah, which really takes me to kind of the last thing we wanted to talk about before we hit some of the questions, which is, okay, I've got this severance package, taken a look at it, or a lawyer has told me, like, it's not what I'm entitled to. I think I'm entitled to more. How do I go about doing that? And so the first thing is obviously don't sign a release, because there's nothing you can do once you've done that. And then the other one is, like Denise said, whatever timeline they gave you, it is a made up number that is meant to put pressure on you. The only two numbers you need to worry about are generally, again, if you're working for an employer in Ontario, a year to file a human rights complaint. So if you're saying it's been discriminatory, you have a year, or 2 years to sue. If you work for a federally regulated employer, we probably should have flagged this at the beginning. So let's say you work for a bank, or you work for Bell, or you work for Rogers, or you work for what are called federally regulated employers, which if you're not sure, I suggest you Google and try and kind of figure it out, or again, get advice. There's what's called unjust dismissal, which is an entirely different regime that we're not going to talk about, but it has a 90-day limitation period, meaning if you don't act within 90 days of your termination, you would actually be losing significant rights that you have. So again, this is one of the reasons why we always encourage people to get legal advice, is to be able to figure out, okay, am I provincially regulated or federally regulated? Because that is how the actual timelines that matter for you are determined. So again, 90 days if you're federal. If you're Ontario, so you work for, again, you work for IBM, or you work for a big tech employer, it is a year for a human rights complaint, 2 years to sue. So those are the only timelines that really matter for the most part. What the employer has told you is just to put pressure on you. The way in which people negotiate, frankly, is all over the place. And I'm going to start with the first one, which is sometimes it's not to negotiate. For some people, what is offered is fair. They already think they're going to find new work pretty quickly, and they don't want the cost or hassle of negotiating with their employer, which, I get. It doesn't resolve overnight. It's expensive sometimes, depending on what the circumstances. And for some people, the right move is to just accept. The second, though, and this is more common, is people try and negotiate. And, how you do that really is going to depend on your own situation. A lot of the way people do it is they hire a lawyer. What lawyers do is they usually send what's called a demand letter, which is just a letter that says, here's what my client is entitled to. You've paid them less than they're entitled to, and here's some kind of offer to resolve the situation. So some amount that's maybe a little bit less than you're entitled to try and get the employer to just effectively cave without making you sue. And that is actually the most common way that these things resolve. More often than not, through sort of negotiations, often with a lawyer, people are able to resolve these usually in a matter of months and usually for a few $1,000s in legal fees, depending on how senior a lawyer you are, how complicated your case is, all that kind of stuff. But that is one of the ways people negotiate. There are some people, though, that feel comfortable to do it on their own, or they actually feel like, you know what, I have a really good relationship with the manager or the HR person who let me go, and I'm worried about blowing that up. Could I maybe send a letter, or could I try and negotiate on my own? And sometimes that makes sense. And, you know, Denise and I have both done this, where we just kind of hang in the weeds. We give people like little bits of advice, and they will just go and try and negotiate. And that is really a good strategy, where you have the personal relationships that you can leverage to try and, you know, basically say, hey, we worked together for 10 years. Can you throw me a bone? You just fired me. Like, I'm trying to move on. I don't want to have to, you know, go use my lawyer. Can we just do that? And that can actually be pretty effective sometimes. The other time that can be effective is where, you know, frankly, the cost of hiring a lawyer doesn't really justify or isn't justified by what you might get. And so you go, you know what, I'll just get some background advice and then I'll go try and improve this on my own. So sometimes people do it that way. The, you know, break glass in case of emergency option in terms of how to improve your package is to sue. That usually needs a lawyer, but not always. Like, some people are able to go after their severance packages in small claims court by themselves. It gets a little bit more difficult if you're not in small claims, and frankly, small claims can be pretty difficult without a lawyer. But anyways, usually that requires a lawyer, and you're looking at tens of thousands of dollars for suing. We're not going to spend much time on that. But, you know, we would almost never recommend just jumping to litigation. It's not usually a good strategy. Most things are able to be resolved without litigation, and the cost of litigation is way more than the cost of trying to resolve something out of court. And even if that sort of informal negotiation process doesn't work out, there are other sort of screws that a lawyer can turn to try and get some kind of improvement on severance packages. Sometimes you go to a mediation, which is just basically it's a meeting with a mediator who helps the parties try and solve the dispute. But there's other sort of strategies that lawyers will generally use to try and improve the package. But, you know, generally that is kind of how people usually go about it. And a lot of it is going to depend on your situation. Like, what makes sense, you know, is going to be a factor of, well, what are you owed? And how much you spend on that is going to largely be a factor of what are you owed. So in terms of sort of the scripted things that we wanted to go through, I think that's it. There are a couple of questions that I see. Maybe I can run through them, Denise. The first one was about what happens if the deadline passes, and we already dealt with that. The next one, Denise, maybe you can handle, is, will negotiating hinder my chance at getting a reference?
Well, that's a really good question, because I would say that your employer, you know, should be giving you a reference, because it's in their interest to have you find new work. And that goes back to the duty to mitigate concept that we were talking about before. So, I mean, in a perfect world, negotiating wouldn't hinder your ability to get a reference, but I would certainly be making a note of any refusal to provide a reference for actually as leverage in the negotiations if if the employer refused to provide it, because again, it makes really no sense not to do it from the employer side.
Yeah, and just to sort of add to that too, I missed this when I was going through my stuff. The bad faith damages, human rights, and sort of your notice period damages aren't the only things that you can negotiate. You can often negotiate a letter of reference. Like, you can say, look, I'll sign your release, but you have to agree to provide me with a positive reference. And if you're called, you'll agree to provide me with sort of positive verbal references too. That's often pretty standard first ask, frankly, as part of any negotiation. And some employers will, some, as Denise said, some won't. Some like to make their lives harder for reasons. But in any event, that's one of the things. Other things that we often ask for and can be negotiated is outplacement counseling. So those are professionals who will help you look for a new job and improve your resume and do all that kind of stuff. Legal fees, often probably more often than not, the employer will pay some portion, if not all of the legal fees. Not always. Often it depends on, have they improved the package at all, or are they, thinking that they've given you everything you're owed? But more often than not, they will pay the legal fees. Trying to think if there's anything else, sort of, Denise, that I've missed as part of sort of some of the standard things that often get thrown in. The way it's allocated can sometimes get negotiated. So, often human rights and bad faith damages have a different tax treatment than salary or notice period damages. And so sometimes what you can do is negotiate the way that gets allocated to have it paid out in a more favorable tax way. Or similarly, they can agree to put it into your RRSP so that there's no withholding. So instead of you getting paid $50,000, that's all taxable, you can direct that $50,000 into an RRSP so you don't pay the tax. And again, that can often be negotiated. Anything else that I'm sort of missing, and as far as sometimes what goes into the offers to settle?
Well, the way that the deal is structured is really going to depend on the particular circumstances. So, for example, say that you need access to your disability benefits, and you still need access to your sickness benefits. Salary continuance might make more sense then, because it's easier for employers to continue those benefits on salary continuance versus just paying it out in a lump sum. So things like that that are important to turn your mind to, and depending on what type of pension you have, it might be more appealing to do the salary continuance if you have a certain type of pension that would benefit from that type of structuring of your deal. So things like that are all important considerations when you're looking at structuring any kind of a settlement that you have. And it can be, again, it's a negotiation, so it's a back and forth, and it's not just you get told what you're going to accept and then you have to accept. There's it's supposed to be a back and forth, and you're supposed to, at the end of the day, get to a point where you don't have the perfect solution, but you're comfortable with the solution. Comfortable with settlement.
And just maybe we can do one last question, is, do I have to tell my employer if I have a new job offer?
If you're asked if you have a new job offer, you have a duty to tell them. You cannot lie. The offer, okay, so I'm going to backtrack a little bit on that, because offer is different than if you have if you have accepted employment. So I would still say that if you get asked, do you have a job offer or have you started new employment, to both those questions, you need to answer truthfully. You at the end of the day, you can't lie if you're asked if you have new work.
Yeah. And again, that's one of the reasons why some people, they might be like, oh yeah, technically you're entitled to 12 months. They may accept 3 or 4 because they have a new job. Like they come, they see a lawyer, and the lawyer says, yeah, you would be entitled to 12 months, but you've told me you already have a job that you've accepted. And so the second the employer finds out about that, there's no way they're going to pay you out the 12 months. Like, that's just not going to happen. And so I often describe it to people as like, your biggest risk is the fact that you're going to find a new job and how soon that's going to happen, because the duty to mitigate, I think there's probably nothing more important that we've said during this call than understanding how that works and operates, because it can just take a jackhammer to your severance package. And it's a really rough situation where you've been negotiating, people come to us all the time and say, I will never find another job again. I have this very specialized skill and there's just no opportunities for me. And then, 3 or 4 months later, as we're in the thick of negotiating things, you get kind of a sheepish call from the client saying, so, when I said I would never get a job, anyways, I've got a job. And it really throws things for a wrench, especially if the employer has asked us, has the person found a new job? Because like Denise said, we can't lie and you can't misrepresent. And if you tried to sign a severance package where you misrepresented, it would probably get set aside by a court. So, it is a tough situation, but if the employer never asks, you don't have to tell them. And it's surprising how often they don't ask and for how long they don't ask. So often we can kind of skate around that a little bit, but if you're asked directly, it can pose challenges.
And just to kind of jump off of that point, certainly before you're deciding whether or not to sue, you want to be really looking at when your losses have crystallized. So if you're at month 2 and you're entitled to 5 months of reasonable notice, some people might say, you know what, I'm going to keep doing what I need to do to try to find new work. But if I don't, then it'll make sense for me to sue. Because if you mitigate at month 2, then, your losses are they're not as great. So, yeah,
Yeah.
mitigation, that whole beast is something that you just need to have a pulse on.
Yeah, I've had people wait over a year before, where, because
Me
like
too.
I said, you have 2 years to sue from when you've been let go, and so they'll wait the full year to sort of see where their damages end up if they find a new job, and then if at the end of the year they haven't found something, we sue, and there's no prejudice. It doesn't impact their case by having waited that long.
Mhm.
So I think we'll wrap it up there. Been going for about 45 minutes or so, so that's probably a good length to cap this thing at. So thank you very much for taking the time to listen to this, and hopefully it's been helpful. We do know how tough these situations are, and so really, we think it's important that people know and understand what they may or may not be entitled to, just so that you can make a good decision before signing any kind of a release. So like we've said throughout, we strongly encourage you to get legal advice if you are in that situation. And yeah, that's it from us. So thank you very much.